Appearances for the prosecution.
Morning, Madam President. Good morning, Your Honors, to everybody in the room. Julian Nichols with Edward Jeremy, Sylvie Wakchom, Zinzana Ziayo, and James Hardy. Thank you.
Thank you very much. And finally, the representatives for the victims.
Good morning, Madam President, Your Honors, Ann Grabowski, and myself, Paulina Massidda, for the victims today. Thank you.
Yes, Ms. Massidda, can I just clarify something while you're on your feet? I know you're the only representative appearing today, but the pretrial chamber, I think, appointed 3 of you. Can I ask which of you is lead counsel?
None of us, the 3 of us are lead counsel, actually. The way in which we work, we normally agree on a common position before any hearing before the chamber if necessary or anything. So we actually act as a single team. This is the expression which was used by pretrial chamber. But we don't have a formal lead counsel in the team, and we take our decisions jointly and collegially.
Yes, all right. Well, I mean, that, of course, is a matter for you. But I want to make one thing clear. Only one of you from the 3 that have been appointed will be asking questions. I'm not going to have 3 people asking questions during the course of the trial.
Can reassure Madam President, this is also our understanding.
Right.
And we will always be in agreement between the 3 of us who will be leading a specific questioning for a witness or a specific arguments in court. So in other words, also for legal arguments, only one of us will address the court.
Right.
Thank you.
That's very helpful. Thank you very much indeed. All right. I don't think we've got anybody here from the registry this morning. So we might as well move to, as I say, what is a relatively short session. The first item on the agenda was the deadlines for the filings of observations to the expert panel for the reports. And we set, I should make it clear, the experts who are going to examine the accused. We set the following deadlines: the 18th of August for the experts to file their reports. 24th of August, the registry was going to file the experts' reports. Right. And 31st of August, observations from the parties and participants, including any request that may be made for an actual hearing. Now, Mr. Nichols, the Office of the Prosecutor requested this item. Is there a reason for that?
Yes, Your Honor. Thank you. Really, what we're asking for is one more week to file our observations, and then, of course, if necessary, another week for the defense and for our friends in the LRV. The reason is very simply, on the 31st of August, we're going to have to file our pretrial brief, our list of witnesses, our list of evidence, complete our disclosure, and then this will, I'm sort of asking for mercy. This will drop on us, and we can't really start writing it early during that last week as well, when we expect to be extremely busy, and depending on what the outcome is of the reports we receive on the 24th, it may or may not be quite a lot of work. So we're just asking for one more week to file so that we can have more time after our deadline for all those other projects. I think there's a total of like approximately 10 that we have due on that date. And so this is formally under Reg 35, but I don't see that this would slow things down substantially in any real way, and certainly not the start of the trial date if we're given that week. So those are the grounds, and that is the request.
It's not. If it was just that, Mr. Nichols, but it's the knock-on effect, because as you say, if we give you an extra week, well then we'll again have to give the defence an extra week. Well, I suppose it's everybody at the same time, isn't it? Okay.
Your Honor, I think we were filing simultaneously.
Yeah, yes.
So,
No,
so it won't have that extra that I think you may have been thinking about.
Yeah, sorry, you're quite right. Mr. Haynes.
We've got no difficulty with you showing some mercy to the prosecution.
Miss Merceda?
Same with us, Your Honor.
Yeah. It's all right. We'll be merciful, Mr. Nichols, as it's early on.
Thank you very much, Your Honor.
And you can have the extra week. Then the next item, it was the adoption of the protocol of confidential information. I think you've all seen that it's really the standard one that appears in all trials. Does anybody have any comments on it?
No, Your Honor, just I thought it hadn't been formally adopted yet, unless I'm wrong. It was adopted by the pretrial chamber.
Yeah.
The standard one that's annexed to the trial manual. But we were just asking that it be formally adopted at this stage because it wasn't carried over from the pretrial stage, pre-confirmation stage.
Yes,
excuse me.
I think that's right. Well, does anybody have any objections? Otherwise, we'll just order it to be filed, adopted and filed.
We did have a couple of small observations to make about the text of it, which I think, with respect, might be better done in writing. That's been the practice in the past, and it's worked very well. It shouldn't hold things up at all, but I'm sure we can get something across in a few days.
Right. Well, that seems very sensible.
Thank you.
I think then we'll simply, we'll wait for your potential objections and see if we want to make amendments, and then we'll instruct the registry to file it, or whatever the procedure is for this protocol. Right, page limit of the prosecution's trial brief. Well, you again, Mr. Nichols, asked for this. How many pages are you asking for?
We'd asked for 160, Your Honor, an additional 40 pages. I think, I don't have the stats, but I think that's almost the standard now with the 120 is the parties asked for some more. That's 40 less than in the Abdulrahman case, and I think we may use a little bit less than that, but we think that's what we really need to write a good brief.
Yeah, and is that with or without annexes? Because you got some help. You had some helpful annexes attached to the pre-confirmation brief.
Yes, that would be without annexes. We will avoid that issue that came up in the last trial about substance in the annexes that should have been in the brief, but that would be without the annexes, so that would include maps and charts.
Yeah, that's right. Yeah, I think we are all. Yeah, we all agree. Yes. All right.
Thank you very much, Your Honors.
Right then, we're going to give some dates for the next status conferences. There'll be one, as I think we've already given the date, the 14th of July. Is that right? These are all dates that we'll put into the calendar, but if it turns out there's no need for anything to be discussed, then we may vacate them. But otherwise, it's 7th of September, 13th of October, and then the 2nd of November. I rather feel the one on the 7th of September, because by then we'll have had the reports, is likely to be an important one. And for that, certainly, Mr. Haynes, we would expect Mr. Duterte to be here, unless there's some medical issue. The final matter that I want to raise is this. And that's the question of statements being made by counsel to the media. This case has attracted, not surprisingly, a substantial amount of media interest in the Philippines in particular. That's not, of course, only mainstream media, but as is common these days, social media, and additionally appears to have provoked suppliers of what is undoubtedly fake news, and obviously fake news. The first thing we wish to emphasize is the need for the media to report to the public accurately and fairly what is said in court, and above all, to avoid speculation. That is important in any trial, and it's doubly important when it comes to a trial of serious allegations. And nothing could be more serious than these of criminal activity. Can I just issue a reminder to the media that anything which is said in private session may not be reported. Part of the reporting of the earlier proceedings in this case was not assisted by comments made by previous defense counsel Nicholas Kaufman to the media. On the 3rd of October of last year, the pretrial chamber issued a reminder to him to remember that he had a professional duty to be respectful and courteous to the chamber. Regrettably, that reminder had no effect. On the 26th of April of this year, after the appeals chamber had made its decision on jurisdiction, Kaufman gave at least 2 interviews commenting on the decision. Some of those comments were his personal view of legal decisions made by the court as a whole, and were on any showing wholly inappropriate. The more so when made by counsel in the case. In the light of this previous history, this trial chamber feels it incumbent to repeat the reminder or warning to all counsel in the case, for the reasons that I have already expressed as to the importance of this trial. We see no reason why counsel should feel it necessary to make any comment to the media. The appropriate forum for counsel to raise matters is in the courtroom.